it's a head thing too. Yeah, your point is worth it.
Okay, let's move into the declaratory orders concerning the Colorado Medical Marijuana Code. I don't know that I'm going to read it line for line. I will explain it generally to the group. Kevin, did you have a question?
No, after you're done explaining it, I have a comment.
Generally, what the declaratory order process does is it creates the ability for the industry or other interested persons to petition the Medical Marijuana Enforcement Division on various issues that are of concern to the industry. And there's some safeguards put into place here. For example, if there's a perceived violation that's pending a hearing by a local licensing authority, we're not going to intervene and step in. That's something that's between that industry person and the local authority. There's some checks and balances put in place. But generally, it creates a protocol, an additional step, if you will, that ensures communication two ways so everybody knows where everyone stands on a specific issue. And the division can issue something called a statement of position on any of these issues. So if you have a question concerning anything that is currently in statute, you have the ability to ask the Medical Marijuana Enforcement Division for its position on what that specific thing means, whatever it is, okay? If you get a response from the division, or the division fails to respond, you have the ability to ask the same question as a matter of law directly to the state licensing authority, who can issue something called a declaratory order. Declaratory order is considered agency action on behalf of the Department of Revenue, and it is then subject to litigation or 106 action through the district courts. This process is in place, and I find it to be a very good tool because oftentimes people dig their heels in, and I'll just say it. They dig their heels in on a specific issue, and they don't want to play their hand, if you will. This forces that communication before you have to go straight to district court. It saves a lot of time, it saves a lot of money, and the reality is oftentimes the state licensing authority may see things in a little different light than the Medical Marijuana Enforcement Division. And so I think it's a very good tool. This is something that is currently in statute in many of the other occupations that I'm involved with. This is almost verbatim, I believe, in the Pharmacy Act itself, the regulation of pharmacies. A very good process. So I encourage the adoption of it. It may need some wordsmithing. I did find on page 16, subsection E, a copy of any petition, a statement to the Medical Marijuana Enforcement Division, a petition for declaratory orders to the state licensing authority shall be mailed, comma, and it should say maybe by the Medical Marijuana Licensing Authority or something along those lines on the same day. It's a minor detail. Give me your thoughts. What do you think? What have we missed here? Kevin?
One question that came up, and I honestly don't know how it works with the same stuff in the liquor code, but it's presumed that a person could be a local government entity, but since we're doing this from scratch, might it make sense to insert that a person might also include a municipality or a county or a local licensing authority or something of that nature?
Sure. Yeah, I'm not opposed to any person or local licensing authority or local government, or what's your preference?
Municipality or county?
20% common municipality and county.
Actually, municipality, county, or city and county. No.
Yeah, they've been practiced like that.
Right.
Yeah, that's fine. Master Dill.
It may be unnecessary, but I wonder if you want to include the state attorney general's office as a recipient of the petition, even though they're in your office, and normally it would be advising you as more or less house counsel on whether you can include them in the distribution list.
Any thoughts on that? See any tainting of the process or anything along those lines? Would you check?
Yeah. Let me ask a question. I just want to make sure that I understand this, because obviously this is a lot of, legalese kind of talk. So when you're talking about a petition, if I write you a letter and ask you, what is the department's position on some kind of an issue, that would be considered a petition in this situation. And what you're talking about, a statement of position, then that is your response to whatever my request for information is. Is that an accurate?
There are times where people just ask and say, how does the division interpret this or that? And we do that routinely. I've been doing that through email, as most of you know, ad nauseum for the past several months. But this is a more formalized process. It's formalized because it really creates a record should there be a need to litigate it. And for example, you may send me an email and say, Matt, what's your position on this? Or what's the Marijuana Enforcement Division's position on this? I'll send you an email back and say this. And you'll say, no, that doesn't make sense. You have an option then to say, I want to ask for a statement of position, which is the division's formal position on that issue. And then the declaratory process kicks in place. It's then subject to appeal to the state licensing authority, who could issue the declaratory order under the circumstances. And from there, it has the ability to go directly to district court. Yeah. Yes, Ed.
Is there any way that any of these petitions are put on the website for everybody to be able to see them?
They are. And the other thing that needs to happen with this process, usually when a statement of position is issued and a declaratory order, if it gets to that process, I've encouraged all the divisions to put those issues on their rulemaking list on an ongoing basis. If that's going to be the position, that's the position of the agency, and it becomes final agency action, it should be something that at least ends up in a rule. But we obviously can't do rulemaking every month, perpetually. Generally once a year, based on need, and that's generally done at the end of a legislative session because they bombard us with new laws, and oftentimes we need to go into rulemaking to clarify them. So
Could we put something in the rule that says within a certain amount of time that the department will post it to the website? Will post it publicly?
sure. F comes as close, subsection F under 6 comes as close to that as we can, but we can word